Good evening, everyone, and thanks to the Strata, by the way, for hosting this. It's great to be able to use this space, and it's wonderful to be able to actually be in a Strata environment as opposed to a facility that we often use. So I'm going to talk more about the practical function of what we're going to be dealing with respects to tribunal. There are certainly some practical applications, some kind of linear steps in thinking of things that we're going to be doing as we go through this. And I think that when you look at it from a perspective of a Strata Council, what we really want to say is, so how does this affect us? How does this really change the day-to-day operation, or how does this benefit us as a Strata Corporation? Shannon's slide about part of the justice system is one of the things that I think is very helpful for us to remember. Even though that a tribunal is part of the justice system, tribunals don't form case law. They don't create precedent. So each dispute, the merits of each dispute, the facts of each dispute, they're held differently, they're addressed differently. And certainly we know from the 32,000 strata corporations in British Columbia, no two are alike. No circumstances are alike. No set of bylaws are alike. The conditions with respects to ownership and transition of ownership and strata councils and the volunteers, all of those things are different in every environment. So the outcomes of these decisions may be different in a variety of ways. It's about problem solving for your community. And that's the essence of a tribunal system, is to be able to get to the heart of your problem within the very specific topic, in this case strata, and how that's going to be focused on the specific legislation, which is the Strata Property Act. I think that's the greatest benefit, is the anticipation that you will get someone to serve you that is already speaking your language, to be able to help you understand where the solutions are going to come quickly. Tribunals, specifically the fundamental purpose of this tribunal system, is based on common law. And within the nature of the structure of common law, it's about ordering somebody to do something or stop doing something or order somebody to pay something. And that's the essence of strata living, really, in a strange sort of way, is we are doing things, we're managing, maintaining, operating our stratas. We have owners who function within our bylaws, our rules. So it's all about doing something or not doing something if they're violating one of our bylaws or rules, or about ordering our strata councils to actually comply with the act, enforce the bylaws, comply with the regulations, meet their obligations for things like maintenance, repair, and to be able to provide information to owners. So the tribunal structure is really about these three basic principles. And each one of them can be applied in some sort of test as you go through the Solution Explorer, and as you're asking questions, you want somebody or someone to do something or stop doing something, or you want someone to pay for something. And that's going to be the kind of the backbone of what we're dealing with. So a strata corporation can be ordered to comply with the bylaws and the rules. They can be ordered to enforce the bylaws and the rules, which here has been the nature of the problem for strata corporations for so long. The cost of enforcing a bylaw through a Supreme Court application was excessive, in the sense that we were looking at $25,000 to $50,000, required a 3/4 vote of the owners. The strata couldn't proceed without the authority of the corporation. And invariably, all of those people who weren't affected by this bylaw violation voted against it because they didn't want to pay the money for it. So it was a substantial barrier for strata corporations to enforce bylaws. No longer an issue. Strata councils don't go to the owners anymore with respect to a CRT action or enforcement of bylaws. The strata council makes a decision at a council meeting. They give an owner fair notice. You get a written notice. If you don't comply or resolve the matter within 14 days, we are starting or commencing a CRT complaint. And you go through the process of commencing and activating the CRT complaint. So many of the barriers have been removed, which really helps us to be able to deal more efficiently with the operations of our strata corporations. Stratas can be ordered to comply with the Act and the regulations. If you read the column, and on a weekly basis, a lot of it has to do with strata councils not complying with the legislation, unwilling to provide records or documents, unwilling to enforce bylaws, unwilling to maintain and repair property, unwilling to allocate property fairly. You know, there are so many little anecdotal examples that I could give that it's fairly obvious that a simple ordering a strata to comply with legislation is something that should be an easy task to achieve for an owner, not something that should be an onerous task with barriers. We have a very fine example of this in the Okanagan Strata Corporation, 36 units. They have 36 underground parking spaces. One would think logically that every strata lot would have one parking space, but yet there are 8 people who park on the street because the president and the treasurer both have multiple parking spaces, right? Simple application about the fairness of allocation. We all laugh about that because it kind of hits close to home in a variety of ways, right? But the simple fairness and application, it's about fairness, really. When you live in a strata property, your home is not your castle, you share the castle. And sharing that property means you act fairly. You enforce bylaws fairly against different owners and different parties. Another anecdotal we see with respect to the enforcement of bylaws is the fair enforcement of bylaws. So we'll have a bylaw that limits the number of pets to 1 cat or 1 dog. And some people might have 2 cats or 2 dogs, or they might have 3 cats, but you never really see them. And then suddenly somebody comes along with 2 large dogs that the Strata Council doesn't like, and they start enforcing the bylaw against that party. But they've never enforced the bylaw against all of the other owners. And so we now come under a situation of fair enforcement of bylaws. And these are the challenges you're going to start facing as strata councils. How have we historically managed our business? Have we acted fairly? Have we enforced bylaws and provided access fairly? And of course, owners, tenants, and occupants, predominantly the owner and the tenant, of course, who have the legal relationship with the strata, those individuals can be ordered to comply with the Act, comply with the bylaws, comply with the rules, comply with the regulations. Many examples where owners don't maintain and repair their strata lots, resulting to damage to other strata lots. That doesn't become a court action, that becomes a bylaw enforcement issue, because the bylaws require that owners must maintain and repair their strata lots. So we go through a bylaw enforcement sequence, which will eventually now evolve to a CRT action, so that there can be an order ordering an owner to comply with the bylaws. This may involve an order of compliance, may involve monetary rewards, or settlements with respect to the amount of money that's necessary for compliance with the bylaws. So there are a variety of examples that will come up as we go through this. Here's some of the monetary issues with respect to paying for money. Damages. You know, the individual, we had an individual recently here in the West End who had his barbecue parked up against the glass railing with respects to the high-rise building, because the bylaw says the barbecue cannot be within 3 feet of the doorways or the building, so they put it on the outside edge right up against the railing, and the heat, of course, has caused the glass to crack, causing damage to the building. Damages are issues you'll be able to deal with, and there's no limit to the amount with respect to the damages. Damages, insurance deductibles, losses that may occur as a result of the actions of owners and tenants, unauthorized alterations, the remedy of unauthorized alterations, the costs associated with those things, and of course repairs and maintenance to common property and common assets. When strata corporations don't maintain and repair common property, it used to be a lengthy, tedious court application that required a lot of money and funding on behalf of a small group of owners, ultimately where the Supreme Court would order the repairs. CRT can take a more positive action into this, and we can, I think, preempt a lot of the long-term damage that's occurring to buildings because strata is simply not doing the work. Shannon covered this, but just a few little reminders. No 3/4 vote required to start the CRT process, but it is a decision of council. It's not a decision of one council member. This is something that has to go to council. And I think that when we go through this process, we're always going to have to step back and ask ourselves some fundamental questions. And the big question is, where did we get the authority to do this? Where did we get the authority? The authority is created out of decision making in your strata corporation, either at general meetings where owners vote by majority vote or 3/4 vote, or council meetings where there's resolutions that are passed to commence CRT actions. If someone has caused a flood in their unit and there is an insurance deductible created, who determined that that person is responsible for that? The strata council. At some point there had to be a decision. And we have to go back to the root of where the authority was created for those types of obligations, and especially with respect to financial obligations. The limitation period, I think, is an essential part of the CRT that we need to look at. We have a 2-year limitation period now. So for items such as insurance deductibles, damages, strata fines and penalties, user fees, alteration agreement costs, which no one has been really looking at, those types of costs, we have a 2-year limitation period to collect. If an owner is not paying them, it gives the strata the ability to proactively get a decision. The decisions can then be registered against the strata lots after the decision has been filed in the court registry, so that you have the ability of securing these. There is enforceability as you move through the structure with respects to holding parties accountable and to collecting the money. The rest of the matters Shannon has dealt with, but here's a basic outline on the type of strata property disputes that CRT will deal with. Application and interpretation of the Act and the bylaws. So just think about this. Interpretation of the bylaws. The question is going to be, are your bylaws enforceable? I think one of the greatest little offenses that strata corporations commit, they take bylaws from other strata corporations, they adopt them, they think they're enforceable, they start applying them. They may or may not have ever been enforceable. No one really knows. They may be enforceable in one strata, they may not be enforceable in another strata for a variety of reasons. And so we need to start looking at our bylaws closely with respects to enforceability. The use and enjoyment of common property or common assets. How are we allocating things like parking and storage lockers, access to facilities? How are we giving one person permission to alter a ground floor patio to consume 200 or 300 square feet of common property when we're not doing it for other people? How are we doing these things fairly or unfairly? Use and enjoyment of strata lots falls right into bylaws, right? What is the purpose of the strata lot? How is it being used? Are you actually meeting, complying with the bylaws of the strata corporations? Actions or threatened actions by a strata corporation. This is kind of an interesting, obscure little line, and people are saying, well, what does that really mean? I'll give you a really great example of what this implication is. You have a bylaw that prohibits rentals, or it limits rentals to 5, let's say. An owner comes to you, requests a hearing with a request for a hardship exemption. And the Strata Council flatly denies it, just simply says, you know what, we don't think you have a hardship, we don't want rentals, we're just simply going to deny the hardship application. If the individual is in a genuine hardship, before the tribunal, their only remedy was a court application. Well, they had no resources to do it in the first place or to be able to pay for a lawyer. But here we have an action of the Strata Council that can now be challenged. We have a decision that may have been unfair, a decision that was maybe not contemplated properly. Another example of decisions threatened or acted by a strata corporation, and again, great example because we now have some case law on this that's great, where a strata council grants a hearing to an owner on their request but says, we're only giving you 5 minutes. And by the way, you're not allowed to bring anybody with you to a hearing, where strata councils are acting unfairly, or their actions are basically prejudicing an owner, preventing them to be able to get any level of fairness. So those are some of the examples where that may apply. Decisions of the strata corporation in relationship to owners and tenants, bylaw enforcement decisions. Who we're enforcing bylaws against. You know, a common complaint that we see every day in our office, and I certainly have seen a few of them even within the last week, where the bylaws are enforced against the owners, but they're not enforced against council members. And the perfect example of that is special levies, where there are special levies and the council are responsible for the collection of those special levies, and the councils will impose fines, penalties, or interest against owners who are late in paying them, but they don't impose it against council members. We see that all the time. Very common unfair behavior. Part of the reason for that is because the decisions around bylaw enforcement are frequently not in the minutes of meetings. So we don't know how councils are actually enforcing bylaws. So there'll start to be some pressure around consistency. And then the last one, which I think is brilliant as an addition to this, is the exercising of voting rights. The age-old problem of one person who stacks proxies and shows up and holds more than 50% of the votes at the meeting and controls the outcome of the meetings. I think if a credible argument can be made that this person did not act in the interest of the owners, did not act in the interest of the Strata Corporation, then there's a reasonable challenge under this provision to be able to challenge the type of decisions that were made and whether they can be overturned in the transition. CRT can order with respect to the holding of meetings. Strata doesn't hold a meeting within the time period. Provide records under Section 35. When an owner requests copies of the owner's list, which will include the mailing addresses or email addresses for notice of meetings, it's a provision you must comply with. They're not secret, they're not private. They're records and documents that the Stratas have to provide. Frequently something, though, that's held out to be a privacy document that the Strata can't release. It's not true. Provision of forms, payment and information certificates. I'll show you an interesting little example of a dispute right now where the Strata Corporation is in a little deep water for providing the wrong information regarding parking. Providing financial information, records and documents around canceled checks. Somebody asked for a canceled check on something. These are all provisions of Section 35. Owners are entitled to these records and to these documents. The CRT can order owners and tenants to comply with the bylaws, so remedying contraventions. One of the juiciest, I think, that's going to come along quite frequently is going to be unauthorized alterations. Individuals do enclosures, they put in hardwood floors, they renovate bathrooms and kitchens, they change plumbing and fire stops and windows and doors. All these types of unauthorized alterations. To be able to go to court, to be able to get an order to order that the restoration of that alteration used to cost the Strata Corporation $30,000 to $50,000. And it would require a 3/4 vote. And frequently the Stratas simply wouldn't vote for it because they don't want to spend their resources on fighting small battles. But a lot of these small battles and Stratas contribute to a lot of major problems. And the Strata Corporations now have access to be able to deal with these issues. Use and enjoyment of common property, common access, it's just general allocation, fairness of allocation of property. Money owing, and I think this is one of the areas where we're going to see some dynamic changes with respect to Strata Councils. For the first time, you as a Strata Council have the ability to start an action that doesn't need the approval of the owners to be able to secure collections and debts. I'll show you a slide a little bit later on, but there are two types of debts that are owing in Strata Corporation. There are secured debts and unsecured debts. We all know secured debts are things we can lien for. Strata fees, special levies, rate of interest, orders by a municipality or a work order. Unsecured debts, fines, penalties, insurance deductibles, damages. But unsecured debts fall in two different classes, which I think many Strata Corporations misunderstand. So using the CRT to get a decision that the debt is owing and paid is going to be much more essential for a Strata Corporation to be able to collect them. Show you that in a minute because it's going to have quite a significant impact. Again, decisions of disputes or threatened action by Strata Corporations, it's basically about fairness. Is the Strata Council acting in a fair manner with respect to the owners? The CRT can also order Strata Corporations to enforce bylaws. A little bit, again, of an age-old problem. It doesn't affect the council, doesn't affect a lot of the owners, but one neighbor is being affected by an individual next door who is a chain smoker. The smoke is causing a nuisance and contaminating the Strata lot. The Strata Corporation doesn't want to get involved, so they don't enforce the bylaw. They don't deal with the issue. An owner can make an application that requires that there is an order ordering the Strata Corporation to enforce the bylaw. They might not like the outcome of it, and it may have other implications for it, but it certainly can be part of the applications that can be made. So going back to the decision making, I think we need to think about the steps that we go through when we're dealing with CRT claims. And the very first step, especially for a Strata Council, is where do you get the authority to be able to do this? One of the challenges that we see frequently when we're looking and reviewing minutes and records of Strata Corporations is that Strata Corporations don't record decisions of bylaw enforcement. A simple decision, owner of Strata Lot 14 has been fined for being in violation of bylaw 3C, pets, the number of pets. The amount of the fine imposed is $100. It provides a record, it provides a timestamp, because remember that 2-year limitation period is running. So it provides a record of the decision, provides a timestamp of when that was imposed, The Privacy Commissioner's information guide says you can record bylaw enforcement decisions with respect to strata lot or unit numbers. So we know that there's permission to be able to do this. This isn't a privacy issue. And it also provides a record of what was decided to future strata councils. That's one of the challenges that we're having. I look at a receivables number on a strata's balance sheet. It might say, you know, $700 fines and penalties. I would hazard a guess it's going to be pretty hard to find a list of decisions in the council minutes to be able to verify where those $700 of fines and penalties came from. They don't just get automatically imposed. It's one of the little mysteries of strata is that strata councils can't delegate the enforcement of bylaws with respect to the imposition of fines to any single party. You as council have to make a decision collectively. And so one of the challenges owners, and certainly it's one of the things that I would raise, one of the challenges owners will have was, well, our council never actually decided to impose this fine. Someone just added it to our account. We don't know how it was created, where it came from. We never had a hearing. We never had notice of it. These are some of the vulnerabilities that I think strata corporations are going to run themselves into. Recording decisions of bylaw enforcement is going to be essential. Decisions relating to financial collections and debt dispute. The Strata Council determined that the owner of Strata Lot 28 was responsible for the leak caused by their changing out their own taps in their unit, and as a result, they are going to be responsible for the $5,000 insurance deductible. We have a decision in the minutes, authorizes the management company to send out a bill. We have a date stamp of when this occurred. In a short period of time, if the owner doesn't pay or their insurance company doesn't pay, we start a CRT claim so that we can secure this debt somehow for the Strata Corporation as we move forward. It's going to take a little bit of linear thinking, I think, as we go through some of these things to kind of get into some sequential patterns. Decisions of hearings. There's another part. When somebody requests a hearing, what is a hearing? You get to respond, by the way. You don't have to be totally silent. So, opportunity to be heard, right? But it's also a council meeting. That's the other thing that's important to remember. A hearing is actually a council meeting. There are minutes taken. When the meeting was convened, the purpose was the owner of Strata Lot 21 requested a hearing regarding a bylaw enforcement issue. We don't record what was discussed. We don't record what was debated during hearing. But we have a decision that comes out of this hearing that you must give the owner within 7 days. That decision can form part of the minutes. These are council meetings. They're not secrets, the fact that council had a meeting. So observers are not permitted at the meeting, but it doesn't mean you don't create minutes of hearings with respect to the proceeding that was undertaken. The confidential and private information is certainly protected. It's not part of the minutes. But the outcome of the hearing and the decision of council, it definitely is part of the minutes. And so these are some of the things we need to start encouraging. And then the other thing is we need to encourage owners to have hearings. As strata councils, if somebody has an issue or you're trying to deal with an issue, make sure that you have a hearing with them. It'll help the process with the CRT go much smoother. You've attempted to resolve the problem. Potentially, with any luck, you actually will solve the problem. But at the very least, you will have met all the conditions of the Strata Property Act, which is basically we give you notice of a complaint, you're entitled to respond in writing or request a hearing, we go through that process, and hopefully if we haven't resolved it, we now have the framework to be able to go through a resolution process. Maintain copies of your correspondence. I think this is one of the things, one of the key issues. Strata corporations have been basically purging their correspondence because the Act only requires you to keep it for 2 years. I'd be keeping it for a longer period of time. It may be material for the type of disputes that you're going to be dealing with. There may be history that's associated with these ongoing offenses. There may be reasons why you'd want to keep this material for longer, especially for things like collections, ongoing bylaw violations, alteration agreements. You keep those perpetually, but if there's any correspondence relating to it, you should keep them as well for the long-term period of time. Maintain suite files and documentation around suites. If you have alteration agreements, you have bylaw enforcement issues, you have maintenance and repair issues that relate to the suites, try to maintain records for each of the suites as well. They're going to help you when you're dealing with CRT complaints. And then, of course, maintain all of your access to all of your records under Section 35 of the Act. There's a very long, I'll answer questions at the end. There's a very long list of records that you're obliged to maintain under Section 35. maintain the records. If you can create an online service, the management companies provide you with a great service for online records. Try to keep them as up to date as you possibly can. We kind of went through a list in the office of typical claims, and I think it's going to fall out pretty consistently with the CRT too. I think we're going to see a lot of claims around bylaws. Because we have so many bylaws that people have just created off the cuff. They're questionable as to whether they're enforceable, how they're enforceable. Claims on money. Money will be the root of many of the problems, and in most strata corporations, money is the root of all problems anyhow. So, and remember, stratas are just big families except for all in-laws, right? So, you know, that's the challenge we face. Challenge of the fines that have been imposed. When strata corporations impose fines and penalties, expect to see challenges of those. Did you do it correctly? Did you do this fairly? Why should my parking and visitor parking have constituted with a $200 fine when you only charged somebody else a $50 fine, right? You need to think of the balance of how you're actually applying these. And then the other basic is for the strata to actually comply with the act, to enforce bylaws, comply with the legislation. Here's a really good example. We've been doing some tests internally to try and find where some problems are. But here's an example of a type of dispute that you can easily see. So I just cut and paste these. So you're going to see that there's actually a grammatical error, which makes no sense to me at all, but I went with it anyhow. So the Strata Corporation had a proposed bylaw in the notice package that said, every strata lot is permitted to have up to 2 cats or 2 dogs. The minutes that were published said, the Poet Amendment bylaws, I don't know what that means, but somebody was typing and I don't know what they did, but that's what it says, was, well, I understand that, but this is the nature of what we read in the minutes. So we'll assume it's the Pet Amendment bylaws, but the Pet Amendment bylaws was passed by 3/4 vote with 37 votes in favor and 5 votes opposed. So we know that it passed. But then you look at what was filed in the land titles. And what was filed in the land titles is every strata lot is permitted to have up to 2 cats and 2 dogs, right? Very common error where you will see someone who corrects the language of bylaws from when they were passed at a meeting to when they're filed in land titles. It's something to check. Double check what you've been doing with respects to your filings. If something's been filed in land titles by error, how do you fix it? You have to have another meeting. You have to pass a correction, you have to repeal what you filed, and you have to file the correct bylaw in its place. And then you run into another problem. What if the owners won't pass that then? And what if you can't get a 3/4 vote for it? So try to act as prudently as you can up front. With respects to general meetings, accuracy is going to be your best friend. Just remember that your agendas for the annual general meetings are created through your bylaws. Follow the agenda cycle that you have within the bylaws, and then look closely at what you're doing with respects to your exact wording and proposed wording. Strata fee calculations, surprisingly, this is a much greater problem than we realize. But strata corporations like to do things like round up. So, you know, what's $285.37? They'll just say, well, it's just $285. It isn't. It doesn't round up. It's calculated based on unit and title formulas. Unit entitlement is filed in the Land Title Registry. You have a legal obligation to use unit entitlement. Every week we come across strata corporations across the province, whether it's the heart of Vancouver or somewhere out in the outside of the rural areas where stratas are not using unit entitlement. The courts have basically deemed that you have to use unit entitlement. They don't order you to go back retroactively, but it certainly has an implication in the long term. It doesn't seem like much with a monthly strata fee of only $263.85, but it becomes a much greater issue when this is applied to a $25,000 levy, a $50,000 levy, or a $100,000 levy. And those are some of the problems we have. Look closely also at the regulations, 6, 6, and 7. You have to show opening and closing balances of all your accounts that are active. So it's the operating fund, it's the contingency reserve fund, and any special levy funds that have not been closed. You have to provide financial reports and financial details for each and every one of them. Special levies, I think they're fairly straightforward, although again, we see a lot of errors in the basic structure of how special levies are defined. But here's an interesting little example. Insurance deductibles for special levies don't require a 3/4 vote of the strata corporation. So strata corporations who have had a number of insurance claims, so their insurance deductibles are $50,000 or $100,000, strata councils can automatically deem these as special levies. And you can levy the owners for the amounts as opposed to diminishing your contingency reserve funds. They're just an example of how you can deal with that. It's exactly the same type of special levy. The only difference is it doesn't require a 3/4 vote. Has a due date, shows the amount, shows the schedule that everybody pays, shows the purpose of the levy. The most important thing, you have to identify it as a special levy under an insurance deductible. That would be the only exemption. I talked about the Limitation Act, but I just want to talk to you about debts and secured debts. As strata corporations, this is something I think it's time to start paying attention to this. So we know that we have a super priority for secured debts. We can lien for strata fees, we can lien for special levies. In most cases, you probably won't use the CRT to collect strata fees. You'll file liens for them, and within a period of time, we'll have a court application for an order for sale proceeding. But don't forget, this legislation applies to every strata in the province. So we have bare land stratas in the interior with minimal services where the strata fees are only $25 a month. All they have is a basic fee to cover their general liability insurance and nothing more. If somebody doesn't pay strata fees for 2 or 3 years, at some point, because of the limitation period, we're going to need a decision. And there's no value in a court application for an order for sale for $500 of strata fees because the legal costs will far exceed it. But you can use the CRT for those types of examples to be able to get a decision to be able to register against the strata lot. But look at unsecured debts, and they do fall into 2 categories, and I think it's important to realize this. Fines and penalties, the cost to enforce bylaws, user fees, alteration agreements, they fall into one category that you can claim on a Form F. But insurance deductibles and damages fall into a separate category that you cannot claim on a Form F unless you have a judgment or a decision from a tribunal. So if you have a judgment from the court or a decision from the tribunal and that's been registered in the court, you can claim those on a Form F, but you can't claim them. And I think I came up with a little example around that. Yeah, it's there somewhere. But again, damages and insurance deductibles, you can claim them, you can get a decision through the CRT for them. That allows you to include them on a Form F. The Form F, the interesting thing, we've already had this happen, where an individual generated an insurance deductible, $25,000 insurance deductible, 2 months later sold his unit. The strata corporation tried to collect the insurance deductible on the Form F to discover you can't collect it on the Form F, and they had no ability to collect the amount. And they have no judgment for it. The time window is such that it made it very difficult. It is one of the issues that if you have a shrewd individual that knows their way around the legislation, they can probably avoid paying for some of these debts. The CRT can help to close the door on some of these vulnerabilities that we have. You can get a decision for it fairly quickly. Enforcing bylaws, follow Section 135 of the Act. It's not a big stretch, right? Simple rules of natural justice. We have a complaint. We give the particulars of the complaint. We have a right to respond. I have a right to a hearing. I have a right to challenge the information I'm given. And then, of course, the strata makes a decision. I have a few scenarios. We have a strata lot that files a noise complaint coming from a strata lot, another strata lot. The strata sends a notice of complaint to the offending party or the accused. The accused party, strata lot 10, requests a hearing. At the hearing, they provide information that they weren't making too much noise but had a family party. So sure, they contradicted themselves in the same little argument. Council then meet and they decide to impose a $200 fine as this is the 3rd such complaint. So the decision is minuted. The minutes showed that a fine was imposed. The fine gets added to a receivables list, and then you start tracking this. Remember, you have a 2-year window to be able to collect this, and before the 2 years expires, you're going to have to make a decision. This is one of those items. It's a $200 fine. If it's the only fine, you're potentially looking at $125+ for a CRT complaint, but it may be your best chance at collecting the fine with respect to the complaint that was filed. If the owner requires a Form F before the 2-year period because they're selling it, there's another opportunity to collect the amount. But the sequence works if you document what you're doing as you follow through the sequence. Here's an insurance deductible complaint. A flood failed from a washing machine hose. There is an insurance claim. The claim proceeds. It's a $5,000 deductible, which is a common expense of the strata. The strata deems the owner is responsible. Good news is the owner or their insurer voluntarily pays. But if they refuse to pay, you can't collect the amount on a Form F if they're selling unless you have a judgment or a decision for it. So try to start thinking about some windows of rules for yourself around time periods. How long do we let a debt go before we commence a CRT complaint? If it's a $5,000 insurance deductible, how long do we let this take out before we then have the vulnerability of not being able to collect it? Once you have a decision from the CRT, you then register it in the court registry, and upon doing that, you can then register that decision against the strata lot. So that gives you the ability to secure the debt in some capacity. It doesn't make it a lienable debt. That's one of the misconceptions in the industry. Once we have a decision, we register it, it becomes lienable. It's not. It's still a low priority debt, but at least there's a chance the strata corporation may collect it at some point. Yeah, I just kind of went through the sequence of what happens if you don't act and you don't do anything about it. I think this is the bigger problem that you'll be facing with your owners. There's a $5,000 insurance deductible. The owner is selling and requests a Form F. The strata has taken no action, can't include the $5,000 debt on the Form F. They can't collect it. So it gets written off as a bad expense, and then you have to deal with the ire of the owners at your next general meeting. I've seen this happen many times in the last 5 years, where strata corporations are writing off bad debts because they've taken no action. Part of that has been because the cost of taking action has been very high. And so the stratas have had to balance what that is. That's changed substantially now at the tribunal. You have the ability to take some action. Maintain receivable charts. Certainly if you have a management company who's acting for you, they're doing this for you. It's an activity I think that everybody deals with. We have a sample in the handout that you can grab. There are a variety of methods of doing this, but what you basically want to do, you want to track the type of debt and the date that it occurred so you can manage decisions within the 2-year periods and the cycles. Here's another issue with respect to the CRT and Form F. If an owner disputes a Form F or the amount that's claimed on a Form F, up to this point they had to start a court action either in provincial court or BC Supreme Court and then pay the amount to the strata corporation. It was a substantial barrier to do this, and so most owners didn't do it. They can now start an action through the CRT and pay the amount. It's a very nominal barrier, and pay the amount in trust to the strata corporation, and the strata corporation of course has an obligation to hold the money separately. So good example, I request a Form F, the strata indicates I owe $2,000, I disagree, I go online, I go through the process of the Solution Explorer, I start my application. Once I've started my application, I give notice to the Strata Council and I pay the money in trust to the Strata Council. My sale goes through without the amount being claimed until this dispute is resolved. So if you do get this example happening, you have to maintain the money separately. It's not part of your operating account, not part of your contingency account. It's an amount that's claimed that must be held in trust. Documents you need to complete a Form B. I'll skip through this quickly. The Form B hasn't changed much, but what has changed is this, that the Strata Corporation, if they are a party to any court, tribunal, or arbitration proceeding, or there are any orders against the strata. So if there's an active tribunal proceeding against the Strata Corporation, that's a party to, or you have commenced a tribunal proceeding against a party, or you have commenced an order for sale proceeding in the courts, or there are any orders against the Strata Corporation, this information has to be included on a Form B information certificate. So it is going to affect how the information is attached, how much information you have to include. You're not including the details of them, you're just including identifying the nature of the dispute and who the parties of the dispute are. But that information, this is a piece of information that is frequently not recorded properly with respect to a Form E. And a Form B is a material document that may influence a buyer's decision as to whether they're going to be purchasing in your property or not. So you need to take these issues seriously. Same issues with number of strata lots that are rented. On the Form B, it says how many strata lots that are rented. This is not the number of strata lots under your rental bylaws or the number you think you have. This is the number of Form Ks you get. And every rental requires a Form K. And so again, a common error that is occurring is this number is being misreported. Last item. Here's a great little scenario that's underway right now. And I know this will be a CRT complaint because the parties haven't agreed to a solution. But we have a buyer who comes along. They request a Form B and for Strata Lot 52. The form is disclosed and shows that these parking spaces, 52 and 53, are allocated by limited common property to Strata Lot 52. Everything seems fine at this point until you look closely at the documents. The buyer has taken possession to discover these parking spaces are actually allocated by a developer lease to Strata Lot 14. They don't have 2 parking spaces, they have 1 parking space. And the value of a parking space in downtown Vancouver is easily $50,000 a space. So they're going to commence an action against the Strata Corporation for incorrect disclosure of information. And it may get covered under somebody's insurance, it may get covered under the party who provided the Form B, but these are the type of errors I think that you can characteristically see pop up. Now, you know, the bad news about this is Strata's in an awkward position. I think the good news is there's probably insurance to cover this. The moral of this story is whenever you have a claim, the first call is to your insurance provider because the defense of a CRT claim may in fact be part of your insurance policy that you have. So there's kind of a practical overview of where we're at. So do we want to answer questions?
I'm happy to, if you haven't had your fill yet.
Shannon is dying to answer questions. The gentleman in the back of the room had his hand up.
So I guess what you're really saying is that as long as Strata Council acts fairly and evenly all around, they disclose their decisions and they make it abundantly clear what the decisions are, then you're not going to avoid everything, but you're going to stay away from predatory legislation.
You know what? Absolutely. Comply with the legislation. And there are going to be individuals who are going to always be looking to pick a fight. There's no way around that. I think that's the unwritten rule of every strata, that you have at least one person who is going to be vexatious or complicated and challenging. But you know, the less that you fail to comply with the Strata Property Act, and the more you can show that you've been acting fairly, the likelihood is you'll have fewer conflicts. And I think this is kind of détente, really. You know, knowing that the CRT is out there, I think it will encourage people to behave in a more moderate level as time goes on. It's going to take a few years. People are going to start seeing decisions published. They're going to start seeing the outcome of decisions, and I think that will be the impact.